Today's video is brought to you by XS Sites. I'm out here today preaching the good word of the XS Big Dot site. If you don't like the XS Big Dot site, then you're wrong. No, I'm just kidding. I started using the big dots because I took a low light force on force class. If you've never had that experience, I could totally see why somebody wouldn't select that site, but it is my go-to site. They offer a whole bunch of other things out there, and XS has been a big time, long time supporter of the channel. So I very much appreciate them supporting the mission here at the VSO Gun Channel. Let's get into the video. What's up, folks? Quick video today. I wanted to update you on something massive that happened. And this comes in the form of a denial of certiorari from the Supreme Court. This is the Worth V Jacobson case. This is a SAF and FPC case, so feather in the cap for those folks out there. And this case comes out of the 8th Circuit. This comes out of the state of Minnesota, and it deals with 18 to 20-year-olds and their ability, are they adults or are they not, to defend their life, liberty, and pursuit of happiness. Their right to obtain a concealed carry license, a license to carry, etc., whatever it is. I don't believe in licenses or their validity as far as constitutional is concerned, but baby steps here. And basically what has happened here is this case started out, some folks sued Minnesota and said, hey, we're 18 to 20-year-olds. We can vote. We can join contracts. We have to register with selective services so that we can be drafted into any branch of the military, perhaps even being handed a crew-served machine gun and told to go over there and die for our country. But we can't own a handgun to defend ourselves while we're here at home. That doesn't make any sense. You guys know that I sound like a broken record right now because I have hit this continuously over the course of the last several years, ever since the previous administration made it their mission to use some of the rights of young adults, but curtail others. And I understand that there are certain things that are going on with our youth right now, and weaponry. I recognize that this is a thing. However, just because a few deranged individuals, let's be real, that are on psychotropic medication, like not just some of them, over the course of the last decade, like 100% of them. And I'm probably going to get in trouble for saying that. Basically, what has happened here is these folks sued the state of Minnesota, and they won, and the state got pissed off that they lost, and they appealed it up to the Supreme Court, and the Supreme Court says, nope, we're not going to hear this case. And basically what that means, and we don't even have a document for this, it's just cert denied, okay? What that means basically is that the previous decision of the court stands. Now, this is a 27-page document from the 8th Circuit, and I'm just going to read you 2 paragraphs that pretty much sum it up, but it's actually a pretty good read if you want to go get it. Minnesota did not proffer any analog that meets the how and why of the carry ban for 18 to 20-year-old Minnesotans. The only proffered evidence that was both not entirely based on one's status as a minor and not entirely removed from the burden to carry, Indiana's 1875 statute, is not sufficient to demonstrate that the carry ban is within the nation's historical tradition of firearms regulations. See Bruin. Minnesota has not met its burden to proffer sufficient evidence to rebut the presumption that 18 to 20-year-olds seeking to carry handguns in public for self-defense are protected by the right to keep and bear arms. This carry ban violates the Second Amendment as applied to Minnesota through the 14th Amendment and thus is unconstitutional. So basically, when the Supreme Court denies cert, there can be a couple reasons why it could deny cert. It could deny cert because it's an interlocutory posture. We've seen a lot of that. Or it can deny cert because, well, it was done right the first time around and there's nothing left for the Supreme Court to do. So the reason this is huge, sorry, I just whammed my mic. The reason this is huge is because while this applies to Minnesotans and presumably anybody who is under the jurisdiction of the Eighth Circuit, which would be Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota, should immediately apply for a concealed carry permit. And if you are denied, you should immediately call FPC. So Minnesota, man, I'm killing my mic today. Minnesota, if you're in Minnesota, then you are basically should be free and clear, right? They basically at this point in time have to issue you a concealed carry permit. But if you're in one of those other states, then you should apply for a concealed carry permit and make them deny you. And as soon as you get that denial, as soon as they say no, you need to walk right over to your computer or your phone and send an email to the FBC and say, hey, look what I got, guys. You want some fresh meat for the grinder? On top of that, the implication here is because we have, and this would likely have to happen in one of those Eighth Circuit states as well, an 18 and 20-year-old, hear me now, an 18 and 20-year-old, you may be watching this video right now and live in one of those states. You need to go to your FFL and ask them to sell you a handgun. When they say no, that you are underage, you're under the age of 21, I can't sell you a handgun, you need to call FPC and understand, work with your FFL and understand that you're going to have to sue that FFL. And that FFL should be very happy to collaborate with you on that whole thing. Because basically, what this decision from the Supreme Court to not take a case means is, again, 18 and 20-year-olds have a right to carry a handgun for self-defense, at least in the state of Minnesota, maybe in those other states. They have a right to carry a handgun, but they cannot currently purchase a handgun. You can now create a lawsuit that will implicate the federal government. And right now is the time to implicate the federal government and say, hey, your ban on the sale and transfer of firearms, handguns specifically, to 18 to 20-year-old American citizens is unconstitutional. You should go do that. You might be watching this video right now and be the person that kills the 18 and 20-year-old unconstitutional ban on American citizens purchasing handguns. You might be the one that makes history. If I could do this for you, I would, but I can't because I live in Ohio, so I'm not in the Eighth Circuit, and I'm definitely not in Minnesota. I'm 38 years old. I do not have standing to bring such a case. But if such a situation were happening in my state, as an FFL, I would gladly volunteer as tribute to help with this. I would call my people from I would be the dude on the phone and be like, give me a plaintiff, FPC. Walk somebody up to me and say, hey, give me an 18-year-old that wants to buy a handgun so I can deny them so that they can sue me so we can go to federal court and end this. Because as someone who grew up in the 90s, well, I guess technically to purchase ammunition, it would have been in the early 2000s. But as someone who would purchase ammunition in the early 2000s, we would have to answer a question: is this ammunition for use with a handgun? And if you were 18 years old and you said yes, they wouldn't sell it to you. And then when I was over 21, I would say yes, even if it was for a rifle, just to piss somebody off somewhere. So I guess what I'm saying is we have an unprecedented opportunity right now for one of you to make history. And I'm telling you, go and do it. That's all I got for you guys today. Let me know what you think about this in the comment section down below. And hopefully we'll see another video here at the VSO Gun Channel.